A dedicated professional career built over decades can be entirely dismantled by a single mandatory piece of paperwork. This is the position Mr. Spring found himself in after his dismissal from his role as a sales director at Guardian Assurance plc. When Spring attempted to secure a new position in the financial sector, Guardian Assurance forwarded a reference to his prospective employer. The document characterized Spring as consistently dishonest and incompetent. Guardian Assurance did not write this reference out of deliberate malice. The individuals compiling the file simply failed to check their facts, drafting a disastrously inaccurate document through sheer incompetence. At the time, the financial sector was heavily regulated by Loutro. Loutro was the life assurance and unit trust regulatory organization, and under their strict compliance rules, providing and receiving these detailed employment references was absolutely mandatory. Because the reference was mandatory and strictly relied upon, Guardian's careless evaluation effectively blacklisted Spring from working anywhere in the industry. The damage Spring suffered is classified in tort law as pure economic loss. This means he did not suffer physical injury or property damage. He lost his future livelihood and total employability. Spring was stripped of his career by a careless corporate error. He desperately needed a legal remedy to recover his lost income, but the specific nature of his damage made finding one incredibly difficult. The dispute eventually escalated to the highest appellate court in the UK, the House of Lords. The Lords faced a distinct legal paradox. Spring had suffered devastating financial harm due to a falsehood, yet traditional common law offered him no obvious path to compensation. False statements that ruin reputations are traditionally governed by the tort of defamation. Careless actions that cause foreseeable harm are governed by a separate branch of law, the tort of negligence. The central question for the court was how to provide a remedy for a careless statement without destroying an employer's right to speak freely. To save Spring, the House of Lords would have to force a collision between the established boundaries of defamation and negligence. Given that the statement was false and deeply damaging, suing Guardian Assurance for defamation seemed like the obvious route, but Spring's legal team knew it would fail. This flowchart maps a defamation claim, which is instantly blocked by qualified privilege. This protects employers giving honest assessments from constant litigation. To bypass it, one must prove actual malice, deliberate spite. Guardian was careless, not malicious. For Spring, this path is a complete roadblock. Under traditional defamation law, employers operated within a zone of impunity when acting with mere carelessness, leaving victims without any legal recourse. Blocked by defamation, Spring's lawyers pivoted to an alternative legal theory. They sued under the tort of negligence, arguing that Guardian Assurance breached a duty of care. This presented a massive historical hurdle. Courts were deeply reluctant to award damages for pure economic loss caused merely by spoken or written words, fearing it would trigger limitless liability for casual statements. The Headley-Byrne exception dictates liability requires an assumption of responsibility. This duty is strictly owed to the advice recipient, but in employment references, the recipient, the prospective employer, suffers no financial harm. Spring, the subject, is isolated completely outside this legal vector. For Spring's negligence claim to survive, the House of Lords would have to stretch the Headley-Byrne doctrine backwards, applying it to the subject of a statement, rather than just the recipient. The majority opinion of the House of Lords, led by Lord Goff, stepped directly into this doctrinal gap. Employers hold exclusive HR data, while employees lack control. Because references are mandatory, employees must rely on ex-employers to exercise reasonable care. This asymmetric knowledge and forced reliance create strict legal proximity. This proximity acts as a direct assumption of responsibility, satisfying negligence. By establishing a duty of care owed directly to the subject of the reference, Lord Goff engineered a new legal bridge entirely over the defamation roadblock. This legal engineering faced a fierce counterargument from the dissenting judge, Lord Keith, who sought to block the negligence route entirely. Lord Keith objected that allowing Spring to win in negligence created a legal backdoor, circumventing the stringent public policy protections built into defamation law. The dissent argued that if every careless reference could simply be sued as negligence, the entire shield of qualified privilege would be rendered meaningless. This split-screen matrix breaks down Lord Goff's crucial rebuttal. He argued that the two torts are not in conflict because they protect entirely different fundamental interests. A bad reference sent privately to a single prospective employer does not ruin your general public reputation. Instead, it surgically destroys your specific ability to earn a living in your chosen field. By strictly separating the loss of general reputation from the loss of economic livelihood, the majority justified opening a brand new frontier in tort law without officially rewriting the established rules of defamation. The House of Lords ruled in favor of Spring, cementing a new standard in the common law. This ruling established the Spring Doctrine. An employer owes a strict duty of care in tort to an employee to take reasonable care in the preparation of an employment reference. This balanced scale illustrates the final legal mechanism. A critical misconception is that the Spring Doctrine makes it illegal to give a negative reference. It does not. Employers remain perfectly free to write highly damaging negative references, provided they can prove they exercised reasonable objective care in verifying the facts contained within them. This instantly shifted the corporate power dynamic. The unchecked ability to arbitrarily blacklist an ex-employee was replaced with a mandate for strict evidentiary rigor. Spring versus Guardian Assurance took the writing of an employment reference from a casual administrative chore and turned it into a high-stakes legal liability, firmly altering HR compliance to this day.